Okay, yes, I don't know if everybody heard that, but I have now switched on the recording function for this. So hopefully we'll be recording the audio part of this webinar. So I hope nobody objects to that. Wanted to advise you all of that. And it's 3 o'clock, and I see that we have now, I think, 13 people logged in of the 40 or so who signed up. So maybe I'll just wait another couple of minutes in case anybody else joins us before I start getting into the substance of the webinar itself.
Hello? Hello?
Hi, Lori, we're here.
Oh, hi.
Hello.
Hello.
Hi, it's Sandra from Solomon Transmission House.
Yes, it's Donna Mercer from McKinsey Counseling.
Hi.
Hi.
Okay, hopefully you can all hear me. This is Mary. I can hear you faintly for those who are speaking, so I think if anybody has a question, it's probably easiest if you can type it into the chat box.
Hi, it's Maureen LaBriviere with Fort Nelson Family Development Society in Fort Nelson, BC.
Hi, Lori.
It's Maureen. Sorry.
Oh, Maureen. Hi, Maureen.
Hi.
Hi, this is Ronnie Beauregard from Golden Safe Homes.
Okay, thank you for joining us.
Well,
it's a little bit after 3 now, so I think I'm going to start getting into our presentation because there's a lot of material to cover, and I'm hoping to leave enough time for some questions and discussion. And so I'm just going to start with a general discussion of what this webinar is intended to do, and it's really essentially give you an overview of the statutory privacy and information protection provisions that apply to organizations in British Columbia. And it's not intended to turn you into privacy law experts, but to give you a general sense of the key concepts and the fundamental provisions of the legislation, and hopefully talk a little bit about how it might apply to the work that you do, so that you then have a sense of when to think about these issues, what rules apply, and where to go to get some more information about the specific aspects of it with respect to which you may have some queries. So I'm going to start by just talking about which legislation applies. There are 3 statutes that you might have heard of or might run across that deal with aspects of privacy and apply to groups and individuals in British Columbia. The first one is the Freedom of Information and Protection of Privacy legislation, which applies to public bodies. And by public bodies is fairly broadly defined, so it applies not just to governments and government agencies, but to a whole range of other organizations which are, according to the regulations, treated as public bodies. So things like professional regulatory bodies, like the College of Nurses, for instance, BC Ferries, I think TransLink it applies to. So all kinds of bodies that carry out public functions. And it addresses not only privacy but also access to information. So if you put in a freedom of information request to a public body or government, it's in accordance with the provisions of that legislation. You may also have heard of PIPA, which is the federal legislation. That applies to the federal government and also to federally regulated activities or businesses. So for instance, banks or airports are governed by that legislation. But the one that I'm going to focus on today, which is the one that applies to organizations in British Columbia, is PIPA, or PIPA, the Personal Information Protection Act. And I'm going to talk about the statutory provisions, but those are not, of course, the only rules that you may run across that affect records management and privacy obligations for your organization. So in addition to the statutory requirements, you may also have to think about contractual obligations. You may have a contract that requires you to adhere to certain rules, particularly sometimes if you have contracts with government funding agencies that require you to follow their own privacy or information protection. Okay, I see from the comments that someone said there's a lot of feedback from other listeners, and could people please mute their phones so that the sound from everybody, because we've got 22 people who have phoned in. So, okay. Oh, I'm going to click on mute all.
The conference has been muted.
Okay. Oh, all right. Okay, I hope that's better now. And so as I was saying, you may have other specific obligations, and particularly I know accreditation bodies that you're involved with may have their own specific requirements. And one of the challenges you may run into is that I think some of those obligations may not fit very well with some of the requirements of this legislation. So I'm going to focus on PIPA today. The principles that apply and the kind of rules in this organization are not dissimilar to those in the freedom of information and privacy legislation that applies to public bodies. But the basic principles I want to talk about here are the ones I've set out here are out in Section 2 and Section 4 of the Act. Section 2 says the purpose is to govern the collection, use, and disclosure of personal information by organizations in a manner that recognizes both the right of individuals to protect their personal information and the need of organizations to collect, use, or disclose personal information for purposes that a reasonable person would consider appropriate in the circumstances. And this really contains in this one provision a lot of the key concepts and themes that run through this legislative scheme. When it talks about organizations, as I said, it means any organization, includes nonprofits, includes charities, includes business organizations. It's a very broad definition. It does not include people acting as individuals or acting for their own personal and private purposes. So if you're collecting personal information, because you're trying to organize a private social event, then it's not covered by this legislation. It's really directed at organizations carrying out their day-to-day functions, whether that's profit-making businesses or nonprofit service organizations. And key to all of this, as set out in both Section 2 and in Section 4, is this idea that the Act is supposed to be interpreted and applied in the way that a reasonable person would consider appropriate in the circumstances. So you're not expected to be perfect in what you do, but to take reasonable care and behave in a reasonable fashion. Now, the challenge with that, of course, is that everybody, or well, people can vary widely in their ideas about what reasonable is. But if you look at Section 2, you'll see what it deals with is 3 types of activities: collection of personal information, use of personal information, and disclosure of personal information. And I'm going to talk about those 3 in turn and the rules that apply to them. And I'm going to talk about some of the key themes here, which are that at all of those stages, whether it's collection of information, use of information, or disclosure of information, very important themes in PIPA are consent, that wherever possible and subject to exceptions, those things should be done with the consent of the individual who's named or identifiable in the personal information. And the idea of transparency, that when you are collecting, using, or disclosing somebody's personal information, as much as possible, it should be clear why you are doing it and how you are doing it. Now, I've been talking a little bit about this notion of personal information being collected, used, and disclosed. So what kind of information is it? It means information about an identifiable individual. And that means not just something that has their name in it, but something that could be used to identify them. So it includes information that has doesn't name the person, but has their date of birth or their address or something else that could be put together with other information and connected to that individual. So you have to be aware that just because somebody isn't named in the information doesn't mean that it's outside this definition of personal information. It's identifiable, not just identified individual. It includes employee personal information, and I'm not going to talk today about the rules that apply to employee personal information, but there are special provisions in the Act. So anyone who's interested in that should take a look at the Act, or feel free to contact me later if you have questions about that. And it doesn't include, it says, contact information or work product information. Contact information in this sense doesn't mean like your home contact information. They're talking about work contact information. So if a document has, your business email address, business phone number, direct line, that kind of contact information is not considered to be personal information, and it's not governed by the restrictions in this Act. So you don't need somebody's consent, to disclose their work contact information. Nor work product information, which is basically information that's produced by an individual or group in the course of their employment. It does apply to personal information that's in that work product. So if a group of people produce a report for the office, information about the people who produced it is not considered to be personal information. However, if the report has some information about clients, for instance, that part of it would be personal information. So that tells you about the type of information, and I also want to briefly point out that the organization is responsible not just for the information that it has in its office, in its own files, but information under its control. So if you have a third party, say, that's doing your financial information processing, or mailing out information for you, you're also responsible for the information that's off-site, as long as the organization has that information under its control. As I mentioned before, the 3 activities that are covered are collection of information, use of information, and disclosure of information. And a lot of the principles that apply are the same for all 3 types of activities, but there are some differences, and I'm going to go over those in the course of this discussion. The general obligations of any organization are not just applicable at those stages, but the Act requires every organization to establish policies and practices to comply with the Act, to establish a complaint process for any individuals who are unhappy about the way those policies and practices operate, and to have a privacy officer. So ideally, every organization, whether it's your strata council if you live in a condo building, or whether it's your credit union or any other organization you deal with, should have policies, practices, and a privacy officer, and should be prepared to make the name and contact information of that privacy officer available. I see Rhiannon asked a little bit about information under control. Does it include databases on a cloud server? I think if it's within the control of your organization, yes. And I would say definitely if that's information that your organization gathered and has put onto that server, I think you are responsible. So it would be appropriate that your organization think about that when they establish their policy, for instance, and their practices, and think about whether they've taken appropriate steps to safeguard that information. Databases where the database developer has access into the database's back end. My technological skills are not great enough to tell you much about it, but as long as it's information that is kind of the property of your entity, then you are responsible. So it's up to you to think about whether the technical safeguards you put in, the databases you use, are such that they comply with the requirements of the legislation. So it's not enough to think about the Act, at the stage of somebody complaining or asking questions about it. You have a positive obligation, or your organization has a positive obligation to, in advance, develop policies and practices that meet the requirements of the Act. And at the end of this, I'm going to direct you to the website of the Office of the Information and Privacy Commissioner, and I should say that there's a lot of helpful information there for organizations that are looking for guidance with respect to good practice in this area. Nobody has to go out and develop a policy from scratch. There are a lot of helpful guidelines there for any organization that's concerned about how to meet its obligations under the Act. Now, as I mentioned before, one of the key principles in this legislation is the notion of consent. And I'm sure all of you have had the experience of filling in some form, answering a questionnaire, providing information to a business or organization, and you are asked to consent to that. And I'm going to talk a little bit about what consent means in the context of this legislation, because there are different types of consent, and there are certain limitations on what your organization can rely on as consent. So first off, the notion that consent has to be informed. So in other words, if you are seeking the consent of an individual to the collection, use, or disclosure of their personal information, the expectation is that they should be informed about why you are doing it and what you're going to do with that information. It's not enough to just say, are you okay with us taking your personal information? Your care card number, your date of birth, your address, your phone number, names of family members, etc. you need to explain to them why it is that you're doing it. A kind of blanket, open-ended consent isn't enough. And as we see when we get to the later stages of talking about use and disclosure, if you get consent for one purpose, that doesn't mean that you have consent for every and all purposes that you might have for the information. You also cannot require them to consent unless the collection, use, or disclosure is necessary to provide a product or service. So, if you are, as sometimes happens, at a store buying something and the individuals ask, at the cash they ask you for your postcode or some other personal information, and you refuse to do it, to provide that information, or refuse to provide some other personal information, they cannot deny you a product or service unless that information is necessary in order to provide it. So if you are asking women, for instance, for some personal information that they're not willing to disclose, you cannot use their refusal to give you that information as a basis for denying them service unless it is absolutely necessary. Not just desirable or convenient or information that you'd like to have. And so it's really important that you think ahead of time about the type of information that you're asking people for, and think in each case about why you are asking for it, how necessary it is, what the purpose is, and what you're going to do if they don't agree to give you that information. Now, I'm going to talk a little bit about the types of consent. The obvious type of consent is express consent, when you have a discussion with them and say, we'd like to keep the following information in our files. Are you okay with that? Here's what we're going to do with it. And they agree, either orally or in writing. But the Act also provides that there may be deemed consent, where they haven't expressly given consent, but deemed consent exists where an individual is deemed to consent to the collection, use, or disclosure of personal information if two requirements are met. First, at the time the consent is deemed to be given, the purpose would be considered to be obvious to a reasonable person, and the individual voluntarily provides the personal information to the organization for that purpose. So, for example, you give information to your library when you apply for a library card so that they can track you down and notify you if you have overdue books, for instance. That's a sort of obvious reason for collecting the information, and you voluntarily provide that information. It's not gathered without your knowledge. That's the sort of thing that falls within deemed consent. There is also a notion in the Act of opt-out consent. It says that an organization is allowed to collect, use, or disclose personal information if they give the individual a notice in a form that the individual can reasonably be considered to understand, that it intends to collect it for that information, gives the individual a reasonable time to decline, and very important, and the individual doesn't, and the very important requirement that the collection, use, or disclosure of personal information is reasonable, having regard to the sensitivity of the personal information and the circumstances. So it has to not only be something where they're notified of the opt-out, but it also has to be reasonable. So you see, for instance, forms that people fill in to enter some draw for a prize that say things like, if we'd like to contact you for marketing purposes, and if you don't want us to do that, tick this box. That's opt-out consent. The Act also provides that consent can be withdrawn or limited. So just because somebody gives you consent at the start doesn't mean that you have it forever, or that you necessarily have it forever. You have to have policies and practices in place that allow them to withdraw that consent if they change their mind afterwards. Now, all of that applies generally. There are special rules for individuals who are minors, seriously ill, or mentally incapacitated. And in those circumstances, you should get consent from a legal representative. With respect to minors, the regulations passed under the Act say that if a minor is not capable of giving consent, then a parent or guardian may give consent on their behalf. Now, that doesn't mean that you have to get consent from parent or guardian every time you're dealing with a minor. As long as the minor is capable themselves of understanding what they're doing and understanding the nature and consequences of the consent, then you're fine to go ahead without having to worry about contacting the adult or guardian in these circumstances. And there's no hard and fast rule. I think the general approach taken by a lot of organizations, medical organizations, for instance, dealing with children, is that as a rule of thumb, most children 12 or older are typically able to give consent, but you do have to think about it in each circumstance. And if you want to know what the rules are about getting consent in those circumstances, the regulations under the Act provide that. And I'm putting in this presentation some of the main elements of the Act just so that you have them in front of you and can take a look at them. But you can also get links, you can get access to all of the legislation and the regulations through the website of the Privacy Commissioner. So if you want to take a look at it later, I'll provide you with information about how to get that. The first step in this process of the collection, use, and disclosure is collecting information. And the Act says that where an organization collects information, it has to have a reasonable purpose. And the collection should not go beyond what is needed for that purpose. So again, it's a good idea to think ahead of time in each case about why are we asking for this particular information, and what exactly do we need in order to fulfill that purpose. And the Act doesn't just say that you are required to think about that purpose and to have a purpose. It also says that you're not supposed to collect information which goes beyond what is needed for that purpose. So, in other words, even if the individual volunteers further information to you, you should not collect that information. If somebody, wanting to be very cooperative gives you much more personal information than you need for the work that you're doing, do not collect that information. Fascinating though it may be. And I mentioned before this idea of transparency and notification, talked about the idea of informed consent, and the Act very specifically says that you need to notify the individual both of the purpose for which you're collecting the information and the person who can answer any questions that they have about it. So ideally, right at the start, when you're asking someone for personal information, you will say, we need it for the following reasons. And if you have any questions about our privacy and policy with respect to personal information, here's the contact information for our privacy officer. Now, it's not always going to be possible to get consent, even the deemed consent. And so the Act contemplates that. You have to remember this Act applies to many different organizations doing all kinds of different work. So it's really drafted in very broad terms to establish general principles rather than specific rules about with a lot of practical detail, because it has to apply to organizations like transition houses and also to businesses, to retail enterprises, to social clubs, all kinds of different organizations. But Section 12 of the Act sets out the circumstances in which you can collect information without the consent of the individual. And the wording here is, the print is very fine, so I don't know if you can see it, but it says essentially that an organization can collect personal information without consent or from a source other than the individual. So this applies not just when, it applies when you're getting information directly from the individual. It also applies to other sources. If you're asking a third party for information about the individual, you need to think about whether one of these circumstances applies. And I put here on this slide the ones that I think are of most application to the work that you do. There are various other circumstances set out in here, such as when you're gathering information to consider whether somebody's going to get a scholarship, or you're gathering information at a sporting event. But these ones are the ones you're most likely to be working with. First, that the collection is clearly in the interests of the individual and consent cannot be obtained in a timely way. If you need information about somebody for reasons that have to do with their health and safety, and you cannot wait to get their consent, because you need to help them now, you need to provide those services immediately, then clearly that provision applies. Or B, the collection is necessary for the medical treatment of the individual and the individual is unable to give consent. If somebody requires medical help, if somebody in one of your transition houses has a medical problem, you can't ask them for the information. You're entitled to take other means to get that personal information, to get them the medical help that they need. C, it is reasonable to expect that the collection with the consent of the individual would compromise the availability or the accuracy of the personal information. And the collection is reasonable for an investigation or proceeding. So if somebody's doing an investigation under the Act is interpreted very broadly. It doesn't have to be a criminal investigation. It includes all kinds of other investigations. So it could be, work-safe investigation, investigation, for child protection purposes, investigation, even if securities fraud is covered by this. Now, Rhiannon asked a question about consent in the case of minors and whether it is whether programs have to get consent from both guardians in order for services to continue. Well, I don't believe you don't have to get consent from both guardians in order to have the consent to get personal or to collect or use personal information of a minor. I'm looking now at the regulations, and it says the guardian of a person of a minor may give or refuse consent to the collection, use, and disclosure of personal information of the minor under the Act if the minor is incapable of exercising that right. So first off, it only applies if the child is incapable of giving consent, and it just talks about the guardian. So if there's more than one guardian, I am assuming that either guardian would do. It would be wiser to have the consent of both if you could, but I don't believe that the Act requires it. And of course, I think that if you were concerned that one of the guardians might not consent, I think you could rely on one of those exceptions, and specifically the exception that says it's clearly in the interest of the individual and consent cannot be obtained in a timely way. There also, you don't need consent if you can get the personal information from public sources. So if you're collecting information by looking in a phone directory or some other kind of publication that's available to the public, that's not something you require the consent of the individual for. Where it's required or authorized by law, which is a very broad possible exception, if it's disclosed to the organization in circumstances where consent isn't required for disclosure, or where it's for provision of legal services to a third party, and where it's collected for the purposes of the organization providing services to a third party, if the third party is an individual acting in a personal or domestic capacity, the third party is providing the information to the organization, and it's necessary for the purposes of providing those services. So if you are providing services, say, to a woman and her children, you don't need, or family members, if one person gives you information about all of them, then you don't need to go and get consent from every single person whose personal information is disclosed to you, if it's necessary for the purposes of providing services. And finally, organization can collect personal information from another organization or on behalf of another organization if the individual's already consented for those purposes. So clearly, if you're working in partnership with another organization and your collection or use of that information is consistent with a consent that the individual's already given, you don't have to get a fresh consent from them every time another organization is involved in the process. Cynthia had a question about, are there any laws that say the consent has to come from the non-abusive parent in the context of domestic violence? None that I know of. I think, again, you only need consent from a guardian in the context of a child who's unable to give consent. And it just says the guardian. As long as there's a guardian, I think that would be sufficient. And no rules about which one would have to be the one giving consent. So we talked about collecting information. The next step is using the information. And again, the Act says only for purposes that a reasonable person would consider appropriate in the circumstances and which were disclosed at the time of collection. So if when you collected the information you had one reasonable purpose in mind, and then later on you have that information, you want to use it for another purpose, it's not sufficient that that further purpose is a reasonable one if it wasn't disclosed at the time of collection. So if you come up with a new idea for using that information, you originally wanted it just to have emergency contact information. Now you want to use it to set up some kind of database, and that's not something you disclosed when you got the information. You will either have to go back and get further consent to using it for a different purpose because you didn't disclose it originally, or you'll have to find an exception to the consent requirement. And Section 15 of the Act is the part that deals with using it without consent. And again, it's very similar to the types of exceptions that were set out for collecting information without consent. Again, if it's in the interest of the individual, if it's necessary for medical purposes, if it's necessary for an investigation, and or it's available from public sources. There's further information of it. You can get it if it's needed to collect debts or pay debts, and if it is necessary to respond to an emergency that threatens the life, health, or security of an individual. So in those circumstances, you can see clearly there are reasons why you wouldn't need to get consent. There's a strong justification for using it without consent. So if you have information in your files and you now need to use it because there's an emergency, that is specifically protected by the legislation. So those are the first two things that are covered by the Act. Collecting the information and using the information. So using it, obviously, within your organization for the purposes for which you collected it. They have to be reasonable purposes, and there should either have been consent or an exception. The final thing that's covered in this kind of three-part series is disclosure of information. In what circumstances can you make this information available outside your organization? And the Act says, again, that you have to think always about the purposes, and the purposes have to be reasonable. That a reasonable person would consider are appropriate and fulfill the purposes that the organization has disclosed to the individual or as otherwise permitted under the legislation. So again, you have to think about, did you properly explain to the individual when you collected their information why you were collecting it and how and when you were going to disclose the information? And if you haven't got their consent, then again you have to find an exception under the Act, some special circumstances. And the sharing of information, Jessica's asked, if a client has consented to two different transition houses gathering information, can the two transition houses share information on the client's stay? I think as long as the disclosure is permitted, so I would think, what was the client told at the time the information was gathered? Were they told that the information might be shared with another transition house? If not, then you have to think whether there are circumstances that justify disclosing it to the other transition house. So when I talked before about that exception for collecting information where they've already consented to the other party having it, you have to think in each case about, did they agree? When they were told about how their information was going to be used and how it might be disclosed, were they advised that the other organization might get it, that the transition houses might share it? And I'm going to now take a look again at the list of exceptions. Most of them are the same as the ones for collecting information without consent. Emergency circumstances, etc. But there are some additional ones that apply only to disclosure. And these ones are to comply with treaty requirements, to comply with a subpoena, warrant, or court order. So if you are subpoenaed and asked for this information, or there's a court order or a warrant requiring you to disclose it, then you are permitted to do so without breaching this legislation, and it doesn't constitute a violation of the rules about consent. Again, you're allowed to disclose it for investigations or making of decisions to undertake an investigation. So if you need to report this because you have a requirement to report suspicions about child mistreatment, for instance, that is permitted under the legislation. If there are reasonable grounds to believe that compelling circumstances exist that affect the health or safety of any individual, and notice of disclosure is mailed to the last known address of the individual. So if you become aware for instance, that somebody is making threats against a specific individual, you're permitted to disclose that to the target of the threats, but you have to also notify the individual who you knew was making the threats. So mail them a notice of disclosure saying we've alerted your potential victim. You're allowed to disclose it for the purposes of contacting next of kin or friends of an injured, ill, or deceased individual. You're allowed to disclose it to your organization's lawyer. And in certain circumstances, you're allowed to disclose it to an archival institution. But other than that, the same general rules apply to collecting information without consent. These are the additional ones that apply to disclosure. So those are all the rules, and essentially they're kind of common sense. It's not always easy to apply them to every situation that you run across, but the key concepts are that you always have to think about the purposes for which you are either collecting, using, or disclosing the information. You should try to make sure as much as possible that that everything you do with respect to the use of this information is guided by those purposes, and that you always have in mind whether the information is really necessary to fulfill those functions. If you don't need the information, you shouldn't collect it in the first place. And if you haven't collected it, then you hopefully are not going to run into problems with how you use and disclose the information. The Privacy Commissioner has been quite critical, not specifically of transition houses, but employers, for instance, asking for unnecessary information in hiring processes. Unnecessary requests for criminal records checks or credit checks. And in fact, just came out with a report in the last couple of years which was quite critical of the practices of the provincial government in their employee hiring and screening processes, saying that too often people were being asked for to consent to criminal records checks or credit checks. Employers have tried to argue sometimes that criminal record checks were necessary in order to reduce theft or fraud by employees. And privacy commissioners in BC and also in other provinces have been quite clear in saying it's really important that you think about not just whether it's desirable or helpful, or you might like to have this information. You have to be stricter than that and really think about whether it's necessary for these purposes. So if you can protect, if an employer can protect themselves against fraud by having better controls over handling cash, then they should do that rather than ask individuals for criminal records information. Because wherever possible, you should think about trying to operate your systems in such a way that you keep to a minimum the amount of personal information that you have to ask for and that you have to use and potentially disclose. The less information that you ask for, then the less likelihood that it will accidentally or unwittingly be used or disclosed in an inappropriate fashion. So for instance, where people are asked to identify themselves, the Privacy Commissioner said, even where it's reasonable to ask somebody for identification, by and large, you shouldn't be photocopying and keeping in files that information. If you need to look at somebody's driver's license to confirm that they are who they are, that may be necessary, but that doesn't mean it's necessary to photocopy and keep that information. So think always about, what's the minimal level of information collection and gathering that is necessary and appropriate in the circumstances. Now the next thing that the Act deals with is access to personal information. because all of the things I've been talking about now, the collection, use, and disclosure, are ways that your organization will work with the information for your purposes in order to provide services. The Act, as I said before, requires every organization to have policies and practices in place for the benefit of the individuals whose information is collected so that they can make complaints or get information about what you're doing with their personal information, and that they can seek to correct it if necessary. So an organization is required, on request of an individual, to provide them with 3 types of information. First, what information do you have under your control? And again, that includes not just information that you have in your files, but information that maybe some service provider that you've hired has. Information about the ways in which the personal information has been and is being used, and the names of individuals and organizations to whom the personal information has been disclosed. So you have to, if somebody asks you, you have to be able to give them all of that information, which means really that you need to have a system in place so that if somebody asks you for that, you're able to provide it. So if you're going to be, when you're using information, you need to be able to account to that to the individual afterwards. You need to be able to say, we've used it in the following ways. And you also need to be able to tell them to whom that information has been disclosed. It's not enough to feel comfortable yourself that you're using the information and disclosing it in reasonable ways. You also have to have some system so that if somebody asks you to account for it, you can provide them with that information. Now, as with everything else, the law tends to operate with general rules and then exceptions to the general rules and then exceptions to the exceptions, so that there's often a kind of tree of exceptions you have to work your way through. And just as there are exceptions to the rule of consent, there are also exceptions to the rules about disclosing information. So if somebody asks you for that information, you're not required to disclose it in 3 circumstances. First, that it's protected by solicitor-client privilege. So if you sought legal advice about a situation, that information is privileged. You're not required to disclose to the individual that you discussed their personal information with a legal advisor. If disclosure of the information would reveal confidential commercial information that, if disclosed, could, in the opinion of a reasonable person, harm the competitive position of the organization, that's not likely to arise in your circumstances. It's more common in, sort of business information about customers, but it may arise from time to time. But the final one where you're not required to disclose it is if it was collected or disclosed without consent for the purposes of investigation and it hasn't been completed. So if an organization is carrying out an investigation, they're not required to while the investigation's still in progress, they're not required to disclose the facts to the individual. Now, that's where it isn't required, where you might choose to disclose it. Even if it's covered by solicitor-client privilege, your organization may choose to let the individual know. But there is another category where you are actually not permitted to disclose that information. So even if somebody comes to you and says, can you tell me whether you have information about me in your control and what you've done with it, in some circumstances you are absolutely prohibited from disclosing it even if you wanted to. And there are 4 categories here. First, disclosure could reasonably be expected to threaten the safety or physical or mental health of an individual other than the individual who made the request. So if somebody comes to you and says, have you got information about me, and you feel that disclosing it might be a threat to somebody else's safety, then you are not just permitted to withhold it, you're actively required to withhold it. So, if you're working with somebody who, in a program for children who witnessed abuse, for instance, and in the course of the work with that child, they disclose information about other parties, and the other party comes and says, I want to know, do you have any information about me? Then if you feel that disclosing it is likely to have an adverse effect on the child or some other party, then you are banned from disclosing it, sensibly. Or equally, if the disclosure can be expected to cause immediate or grave harm, so not just a threat, but grave harm to the safety or the physical or mental health of the individual who made the request. So if the person who's asking about their own information is likely to be harmed, then you're not permitted to disclose that to them. If it would reveal personal information about another individual, or would reveal the identity of an individual who has provided personal information about another individual. So again, all of these circumstances, if information is disclosed to you, and it has to do particularly with violence or safety issues, you are required to think before you disclose it about whether that's going to reveal personal information about others or it's going to threaten somebody's safety. Because if that's the case, then you're not just entitled to withhold it, but required to withhold it. Now, that doesn't mean that the applicant can never get the information. For those categories of information where you might be entitled to disclose, to withhold it, or you're required to withhold it, the Act also says that you may have to still disclose the information if you can edit out the problematic parts. So if disclosure of the information might identify another individual, and you can take out that information before you disclose it to the person it's about, then you should do that, carry out the editing process before you disclose it to the applicant. I'm just going to briefly mention the fact that an individual can ask to have any errors or omissions corrected if they get disclosure of the information about themselves and discover that there's an error. They're entitled to have that corrected. And the Act has all kinds of provisions in it about the process and the timing of requests for information. If somebody's asking for their information, how many days you have to in which to respond. If you face those situations, look at the Act, but there's no point going into them in detail now. Finally, it's important to think about care of personal information. Because an organization has to make a reasonable effort to ensure that personal information collected by it is accurate and complete. If the personal information is likely to be used by the organization to make a decision that affects the individual to whom the personal information relates, or is likely to be disclosed to another individual. So it's not a blanket requirement that you have to take care about accuracy and complete information. If you're gathering information, in order that you can contact people for fundraising purposes, it's in your interests for that information to be accurate and complete, but you're not going to be using it to make a decision that affects the individual. So if, unfortunately, your information isn't accurate and complete, it's not a breach of the Act. The concern here is protecting individuals from organizations making decisions about them on the basis of inaccurate or incomplete information. So again, think about the purposes for which you're collecting the information and how you're using it. And if you're using it to make decisions, say a decision about whether somebody's going to get space in a transition house or whether they're going to be provided with certain services, then you have an obligation to make sure that that information is accurate and complete, or to try to take reasonable steps. You can't be expected in all circumstances to have perfect information, but what you have to do is make a reasonable effort. And that applies, as I said, in these two circumstances: if you're using it to make a decision, or if it's likely to be disclosed to another organization. If you know that the information is going to be provided to somebody carrying out an investigation, for instance, then you've got a special obligation with respect to the accuracy and completeness of that information. Also important that you protect personal information in your custody or under your control by making reasonable security arrangements. So again, it's not a breach of the Act if somebody improperly gets hold of the information, as long as you've taken reasonable care and made reasonable security arrangements. They don't have to be perfect, but they do need to be reasonable. And what that involves is going to be different in each circumstance. Most of the time, for instance, work information shouldn't be taken outside of the workplace. People shouldn't be, taking personal information about clients' home. Computers should be password protected. You should have appropriate security arrangements. And a lot of organizations are concerned particularly about electronic information and hacking. Most of the security problems that have arisen in BC, at least the high-profile ones in recent years, have been through physical problems, like people, leaving a laptop on a bus, or old computers being disposed of without the hard drive being wiped. Not so much a problem of people hacking into your information as just, problems with proper control over physical files, medical files that somehow end up in, recycling or, left somewhere where they shouldn't be. Lori's asked a question in the chat says, management oversight for transition house staff is often off-site and done by reviewing residents' files, hard copy or electronic. Would this be seen as a reasonable use of someone's personal information? I would think so, because it's part and parcel of I would have thought of the process or the reasons for which you're gathering that information is to provide services and to provide properly managed and supervised services, and that necessarily is going to involve looking at the files in order to determine whether the services have been appropriately delivered. So my personal view is that it would be appropriate. I can't guarantee that another party looking at this would arrive at the same conclusion, but I certainly think that seems reasonable, because otherwise you can't, it's a reasonable and I would think necessary way of ensuring that overall the service delivery is appropriate. There's one more thing that I want to talk about, which is required by the Act, and that is thinking about disposal of information. And the Act deals in Section 35 with retention of information. And it talks about, how long do you have to keep it? And there are two provisions which kind of approach it from different points of view. First, if you are using it to make a decision that directly affects the individual, then the organization has to keep it for at least 1 year after using it so that the individual has a reasonable opportunity to obtain access. So if you're gathering this information and using it to decide whether somebody's eligible to receive services, you have to hang on to that information for at least 1 year after making that decision. Because as we talked about earlier, the individual is entitled to find out what information you have, to correct mistakes, to figure out what you did with it. And so you need to hang on to it for a year so that if there are any errors, they can correct them, so that they have a reasonable opportunity to find out what information formed the basis of your decision. And that's the part of the Act that requires you to keep information. But the Act also deals with getting rid of the information, and says, again in Section 35, that an organization must destroy its documents containing personal information or remove the means by which the personal information can be associated with particular individuals as soon as it is reasonable to assume that the purpose for which that personal information was collected is no longer being served by retention of the personal information, and retention is no longer necessary for legal or business purposes. So even if you've used it to make a decision about somebody, once that year in which you're required to keep it, you need to think about when it's appropriate to get rid of the information. And Lori's asked the question that says, I believe that Transition House funding contracts state that files will be retained for 7 years, although the service provider has ownership of the file. Does the legislation supersede contractual requirements? Well, the legislation, again, as I said, requires you to think about these things in a general principled way. So it doesn't say, you need to destroy the files after 3 years or after 6 months or anything like that. It asks you to think about the purpose for which it was collected and whether retention is still necessary for legal or business purposes. So if you look at, for instance, at the provincial government's website, they have all kinds of criteria for different types of information and how long they keep them, emails, reports, etc. I think your organization needs to think about why you've collected the information and when it's no longer necessary to keep the information for that purpose. Now, retention for legal or business purposes is a pretty broad concept there. So if you have a contractual obligation to keep it, I think you could argue that for legal or business purposes you have to retain it because you have a legal obligation, and presumably you could regard that as a business obligation. And I know that also certain accreditation bodies have quite long requirements or expectations about how long you're going to keep the personal information about individuals who received services. But I think it is very important that your organization think about regularly reviewing the personal information that you have on file and either destroying it or taking out any kind of personal identifiers. Because as long as you have that information, there's always a risk that it is going to be disclosed in ways which are unanticipated and undesirable. far easier now than it ever has been to collect large volumes of information about individuals and, to store it electronically as well as in physical format. And I think, we often don't think enough about why we're collecting the information and how soon we can get rid of it. And it is important to remember that even though, this Act requires us all to keep the information confidential, there are fairly large carve-outs for things like subpoenas and warrants. And information that individuals may give to you in an expectation that you're going to keep it confidential, and even if your organization anticipates that it's not going to be disclosed, you may find that you're on the receiving end of some kind of court process, for instance. And this is, always one of the challenges with respect to counseling records, for instance. I've been involved in court proceedings representing sexual assault complainants. And when it goes to court, defense counsel will apply to have disclosure of their counseling records. And, it's a standard practice. There are special provisions not under this legislation but under the criminal code that deal with that. And one of the challenges is, even the counselor and the individual may not be thinking during the counseling process about this potential disclosure, that the counseling records may have to be inspected by a judge, may have to be disclosed to defense counsel. And one of the best ways of trying to minimize the adverse impacts of that is to always think in the first place about how much information really has to be collected in the first place, I think. And also think about how long it has to be retained. Once you got to the stage where it's no longer necessary, unless you really have an obligation from your funders or otherwise to hang on to it, do think about regularly reviewing the information that your organization has and thinking about culling it. Because, Cynthia's asked, how do we best make the case that keeping personal information any longer than necessary is a safety risk for women and children? How do we make the case to funders? Well, I think, you really have to think carefully about all the circumstances in which the information could be disclosed. And I think it's worthwhile, particularly if you're dealing with organizations, say outside the province who may not be familiar with the legislation, to say, look, under the personal information requirements in this province, we have an obligation to not retain personal information any longer than necessary. Now, I can't speak to whether they're going to respect that. I think when you're dealing with funders, you should ask them to think about it. And remember that your funders are also themselves going to be subject to their own requirements with respect to personal information, whether they're public bodies or charitable organizations that might be providing you with funding. And I think you could ask them to think about their own privacy policies. They should all have their own privacy officers and their own privacy policies. So I think, those are maybe the best places to approach dealing with this question, is to think about the people in that organization who are responsible for their own privacy policy. And again, it's very common for all of us to think that the best approach is to keep as much information as possible and to keep it for as long as possible. And, certainly, lawyers have all kinds of requirements that the Law Society imposes on us about when we retain information and when we destroy it. But, even lawyers don't keep it indefinitely. And I think, you're going to have to, again, unfortunately or fortunately, the Act doesn't have any blanket rules that say, this type of information needs to be kept for 3 years or 5 years or 2 years. In each case, you have to really think about what's the purpose. And if you can say, look, we collected this information in order to provide services to women and children, this particular woman and her children, or this group of women and their children, we no longer need it for that purpose. That purpose is no longer being served. Then you have to consider the next question of whether it's necessary for legal or business purposes, and if it's not, then the Act requires you to destroy it. And it talks about destroying documents, but documents in the Act is defined broadly to include electronic media as well. So, deleting files that have the personal information. It's not going to be an easy task to figure out when that stage is, but I think it's really important to remember that it not only requires you to think carefully about collecting, using, and disclosing information, but also when you don't need it anymore, getting rid of it, and getting rid of it as soon as possible. There's some very difficult questions that you have to ask. There are good practice requirements about record keeping that urge social workers, counselors, and other people working with vulnerable populations to make sure that they keep full, accurate records. But this Act also requires you to make sure that those records don't go beyond what is necessary for the purposes of the services. So I think in each case, think carefully about making sure you have enough information to do your work in a professional, conscientious fashion, and also making sure that you don't have more information than is necessary for those purposes. And I can't pretend that that's an easy task for anybody, but that's one reason why the Act requires your organization to have a policy and to think about these things ahead of time, because there are always going to be some difficult balancing tests there. If you want more information about privacy generally, the best place to go is the website of the Office of the Information and Privacy Commissioner. And I put the information up here about that, the www.oipc.bc.ca. And if you go there, it's a pretty easy site to navigate. They've just updated it recently. And there's information for individuals, for organizations, and for public bodies. There are links to the legislation and the regulations. There is a pretty clear guide to the Act, and I think it's just been updated last spring, which gives you a lot of helpful information and guidance about, how do you respond when somebody asks you for their personal information? What do you have to do to help applicants? There are some practical illustrations of, how you can set up your systems and develop policies and practices that help you comply with the Act. Someone's asked, the issue of liability comes up in discussions with organizations. What are the potential consequences of violating the Act? Well, there is more than one consequence. First off, the Act has a commissioner who has considerable powers to investigate complaints and to make recommendations and to give orders. So the commissioner can investigate all kinds of complaints, can require your organization to comply with information requests, can set out dispute resolution processes, have hearings. There's a lot of information in the Act about that process. And that requires the commissioner to take steps to act. But there are other provisions in the Act, and particularly if you fail to comply with an order from the commissioner, that is, it's an offense to do so. It's also an offense to use deception or coercion to collect personal information, to obstruct an investigation. And if you do any of those things, essentially if you don't do what you're supposed to do in response to the Commissioner's acts, then there are hefty fines. An organization can be fined up to $100,000. But generally speaking, the Act provides a remedy in terms of damages that if there is a breach of the Act and the Commissioner has made an order, then an individual affected by it can sue the organization for actual harm that they've suffered. And if an organization has been convicted of an offense. But those require that the commissioner investigate in the first place. And the approach taken generally under this legislation is to try and resolve the situation, hopefully, without anybody getting fined or sued. But it is the potential is there for both fines and also for civil liability. Now, this is said. Kieran has said, we collect information about an abuser for the safety of the woman and the house, and if that information has to be disclosed to police or for other reasons due to safety, are we also required then to notify the abuser that this information is being released? No, you are not. There is a specific exception in the Act for collection of information, use of information, and disclosure of information for the purposes of investigating an offense. So if it's disclosed to law enforcement authorities, Crown Counsel, police, other investigators, then you don't have to notify the abuser or the potential abuser. You do have to notify the notification requirement that I talked about earlier, where you're disclosing information without consent, has to do with disclosure where you know that somebody has made a threat to somebody else, for instance, where you are disclosing it not to law enforcement officials, but you're disclosing it to another individual. So if you became aware that somebody had made a threat against a private individual, and instead of notifying the police, or maybe in addition to notifying the police, you're identifying that you're notifying that individual who's the subject of the threats, then you need to notify the other person. But you wouldn't have to if it's for the purposes of a police investigation, for instance. Now, Donna has asked, if a client asks for information about the abuse they received as a child be documented in the file. Should a counselor comply, this client may press charges in the future. So as I understand that, this is where a client wants to put information down in the file about abuse that they received as a child, and they may press charges in the future. Press charges presumably against the party who abused them. I guess the question there is the counselor would have to think about, what is the purpose of collecting this information? Right? Are you collecting the information for a reasonable purpose that's known to the client, that they're agreeing to? Then I think you'd have to comply. But if it's beyond the scope of what is necessary, so if they want you to keep this information and you think it's not necessary for the services that you provide, then you shouldn't be collecting the information even if they voluntarily disclose it. Now, I would think in your circumstances, that type of scenario, probably you might say it is necessary for the counseling purposes. But, think always about, the nature of the relationship, the services that the counselor is providing, the type of information that they are asking be retained. And I would also, I think, discuss with them the possibility that the information might have to be disclosed in future, because it's not an easy discussion to have with people when you're providing them with counseling, but the law really is very limited in the types of confidentiality that it protects. And, even in the case of sexual assault cases, there is a provision there in the criminal code to try to protect that information and to balance the interest in preserving the confidentiality of the counseling relationship, but the law requires that it be balanced against the constitutional rights of accused persons to have as much disclosure as possible of information that might help their defense. And so I think the important thing is to have those discussions wherever possible at an early stage, so that what you don't end up with is somebody who feels that they've been misled, that they've been deceived about the nature of the confidentiality, because it's not always possible, even in a medical context. And there are all sorts of circumstances in which information may be disclosed that you haven't thought about. Even in the criminal context, even beyond that, it's a regular occurrence that where somebody is injured, in a workplace accident or in a motor vehicle accident, even that they are then required, to disclose all kinds of information about medical treatment and counseling that they've received, because that's part of the process of determining, how much compensation they receive for their injuries. So, as I said before, there's a difficult balance to be struck between keeping full records that may be useful, but also thinking about not collecting too much information and going beyond what is necessary to provide those services, particularly because you cannot always guarantee that that information will remain confidential forever. I see that it's now 4:28, and Cynthia's asked, how do we address blurry areas? Well, I think unfortunately there's no easy answer. And police in transition houses, well, as I said, there are all kinds of exceptions here that allow you to disclose information without consent when you are talking to the police, whether or not to share it with police when they ask for it, but you don't want to give it. Well, here's what I would say is that you will be required to hand over that information if they have a warrant requiring you to do so. You may have specific obligations, say under child protection law, to disclose information, but just because you are permitted to disclose it under the Act doesn't mean that you are required to disclose it. So the exceptions that say, you can disclose information for the purposes of an investigation do not say that you must disclose it for the purposes of an investigation. And I think, I've discussed this before in other discussions with transition house workers, that if you can, ideally it's good to be able to have some discussions with police ahead of time about why you might feel unable or unwilling to disclose some of this information, and hope that you can find somebody in their organization who can, that you can talk through these issues with. I think if in doubt, when you don't want to disclose the information, I think it's entirely legitimate to say to them that you are concerned about privacy requirements and that you want to think about your privacy policy and the question of whether you can disclose this information without consent. A couple of people have asked, Jessica, will this PowerPoint be available afterwards? Is it available for printing use as a resource? And as far as I'm concerned, yes. I don't know about the mechanics of that because this is the first time I've used this particular webinar system. But what I would say is, assuming that the organization is comfortable with it, if you're not able to download it from this conference system, I am more than happy to make it available to anybody by email or otherwise.
This is Kim speaking. We'll make it available on our YouTube channel.
Oh, it's going to be on the YouTube channel? Perfect.
Yes.
Great. Then so it's going to be available on the YouTube channel.
And we will put the link in our newsletter coming out this Tuesday.
Okay.
That we email to our members.
Okay. The link will be
in the link, though,
in the newsletter, so everybody can get it that way. And the other thing I would say is that since I see it's now 4:32, and it's a Friday afternoon, and people have other things to do, I'm not going to keep you any longer. But if you have questions that come out of this that I haven't answered, or you want some follow-up, please feel free to email me with any questions, and hopefully that information will be available in your newsletter as well. So if, as you're discussing this, if you're mulling it over next week and something comes up or you want some clarification, I'm more than happy to address any queries that anybody has. Right? And it's now 4:33, so I think unless Kim or anybody else has any other questions, or I'm going to stop the recording and
thank you very much, Mary.
Conclude this. Thank you very much for your time, everybody. I appreciate it. I've appreciated your questions that have been provided in the chat, and if any of you have any feedback that you want to give me also, I am more than welcome to, I'm more than happy to hear that later. I really enjoyed talking to you. You've been a very patient audience, and I hope this has been helpful to you. As I said, if you want some more information, and feel free to contact me, but do take a look at the OIPC website, because it really is extremely helpful in the guidance that it gives, and you can look at decisions of the Privacy Commissioner for illustrations of these principles. Give you a bit more context than just thinking about the Act itself. So thank you very much for your time. I appreciate it, and I hope this has been helpful to you. Thank you very much.
Thank you. Bye for now.
Thank you.
Thank you. Please stand by.